Are we ready to proceed?
Yes, sir.
Okay. That's good. All right. Are we ready, Ms. Rimmer?
Yes, sir.
Okay. We don't need to do anything with Mr. Denny about the video. He's just let it run during breaks and everything, correct?
Right.
All right. Well, let's get back on the record. Mr. Galvan, despite all our new precautions, such as the wearing of masks, I've been able, I think, to understand you thus far. Have you been able to understand me?
Yes, sir.
Okay. And you've understand questions that I've asked you thus far, correct?
For the most part.
Okay. With respect to what we've covered thus far, is there anything you thought about during the break that you think you need to add to or change or anything like that?
Yeah, one of the things that you had asked in regards to some companies that I owned, I do remember that I do have a joint venture with a company.
Okay. I don't mean to interrupt you in a rude manner. Let me get that in a question and answer format for the transcript, so it shows up better than just going sort of willy-nilly there. Okay. All right. You've identified a joint venture that you're a part of. What is the name of that?
I believe it's called 59.03 Nexus.
Could you say the first two words again, sir?
It's their numbers 59.03, and then the second is Nexus, Nexus LLC.
Okay. Is that a Texas entity?
Yes, sir.
You have a partner or partners in that entity?
I have a partner.
Who is that?
Travis Benz.
Okay. How long have y'all had that entity?
Couple of years, I believe, 2 to 3 years, maybe less, maybe 18 months. I don't know. I would say between 18 months and 2 years.
Do you remember the month and year that you formed 5903 Nexus?
I do not, sir.
Okay. Does that company have members or officers or what?
It's owned by the members. I believe they're members. I do not necessarily know if they're members or officers.
Are there more members than just you and Mr. Bentz?
That's correct.
Right.
Oh, no. No, there are not more members than just me and Mr. Bentz.
Just you and Mr. Bentz. What is 5903 Nexus? Is 53, excuse me, strike that. What business is 5903 Nexus in?
It is in house restoration and leasing, property leasing.
Okay. Does 5903 Nexus own real property?
It owns I think it owns 1 or 2 houses.
Okay. And is in the business of leasing those houses for rental income?
That's correct.
Okay. Any commercial properties?
No, sir.
Okay. Are you and Mr. Bentz have equal shares in that business?
So the individuals or the entities involved with that are companies. One is MDI LLC, and Mr. Bentz has a company involved with that as well. And I don't recall the name.
Okay. But you and Mr. Bentz are in this joint venture through LLCs that you each own?
That's correct.
Are those LLCs inside 5903 Nexus, are those LLCs own equal shares of that business?
Yes.
Okay. Does one of you or Mr. Bentz take the lead role in running the operations?
No.
Do everything together?
Yes.
Okay. And forgive me, I'm this delayed note taking on my part when you were talking. What year and month did you say you started that business?
Again, I don't recall exactly.
Was it in 2000? Was it 2000? I'm sorry, I didn't mean to interrupt. Go ahead.
Go ahead, ask your question.
Was it in 2018 that it started?
Could be. I honestly, I do not know. I don't know.
Okay. You don't know if it started in 18 or 2019?
I think it started in 2017.
Okay. Okay, very good. I appreciate that. Mr. Galvan, are there any other joint ventures, business interests? I'm not talking about a stock portfolio or anything like that you have, but something where you actively participate in a business like you just identified. Is there anything else that you've thought about that's like this 5903 nexus where you have an ongoing business interest?
No.
Okay. All right. All right, let's switch gears here a little bit. I asked you the very first of this deposition if you'd given deposition but testimony before, and you indicated that you have. Do you remember what case that was in?
It was a workman's comp case, and it was, I don't recall the exact name of the case.
Was that related to one of your business entities?
Yes.
Do you remember which one?
Orbit Broadband. Can you, I believe is one of the discovery answers. Can you refresh my memory?
Sure, I'll be happy to. If I can do that, give me 1 second. You're referring to a case where the party was Rubiela Lopez for the estate of Pedro Salazar, the Orbit Broadband.
That's correct.
Okay. Had Mr. Salazar been an employee of Orbit Broadband?
Yes.
Did he pass away in some fashion while he was working for Orbit Broadband?
He did.
What happened, just in general terms?
I don't know if I can answer that with the settlement. I mean,
Objection form in the event that there's some confidentiality, Mr. Chapman. I'm not sure what the.
Sure, I understand. I'm not asking for any terms of the settlement. I just want to talk about the type of lawsuit that it was. Was it a wrongful death case?
It dealt with workman's compensation.
Okay. Was there an allegation that Mr. Salazar had died while doing something on behalf of Orbit Broadband?
Yes, I believe so. I'm not an attorney, so I don't remember.
Sure. And I'm not trying to get you in trouble with any settlement agreement you may have reached. Let me ask you, just yes or no on the record. Was there a settlement reached in that case?
Yes, there was.
And there is some settlement agreement in that case that you believe binds you to certain confidentiality going forward?
Objection form.
I believe so.
Okay. Fair enough. With respect let's start with Orbit Broadband. With respect to Orbit Broadband, has it been a party to any other civil lawsuits?
Not that I can recall.
Okay. I'm going to lump these together, and if I need to break them apart, I'm happy to do so. The other business entities you identified that you own either solely or with your wife are MDI, G5 Internet Services, and G5 Streaming. You understand the entities I'm talking about?
Yes.
have those entities been a party to any civil lawsuits that you recall?
There was and I'm not sure if this is civil or not, but we did have a employee get in an accident, and that employee was then being sued, or we were. I'm not sure if that's civil. I don't know.
It sounds like it is, and I understand you may not have a detailed memory of the incident. Do you remember which entity that involved?
I think it was Orbit Broadband.
Okay.
Yeah.
Was the time in the Salazar case the only other time that you've given deposition testimony?
Yes.
Okay. And you've only been married one time, correct?
That's correct.
So sometimes people don't think about family law issues as lawsuits, but just to clear that up, you haven't been involved in any divorce proceedings or any suits affecting parent-child relations. Is that fair?
Yes, that's correct. I have not.
And thank you for doing that, because I was about to have to correct my bad question and ask if yes was no, but you've not been involved in any of those suits, correct?
I've not.
Thank you. Have you been a party to any criminal suits where you've been prosecuted for a crime in the last 10 years?
Objection form. Answer.
No.
Okay. All right, let's talk about the lawsuit that we are here on today. And the court reporter read that out as 2018 DCL 06387. You understand what lawsuit I'm talking about, certainly, correct?
Yes.
And this is a lawsuit filed by you and your wife, Sonia Galvan, correct?
Yes.
And the defendants to that lawsuit are my clients, Blaine and Hannah Cruz. Correct?
Yes.
Okay. Have you as an individual ever sued anybody else in the civil court before this case?
Not to my recollection. No.
To your knowledge, has your wife been a party in any civil matter as an individual?
No.
Okay. And this lawsuit was filed on or about November 5th, 2018. Does that sound right to you?
I believe so, yes.
Okay. I'm going to attempt to use technology here for a minute. We'll see how this works. Ms. Rimmer, I'm going to attach a copy of the petition in this case and talk about that for a little bit. Let's see here. Okay, my view just changed. Can you see a petition with certified copy at the top and it says temporary restraining order?
Yes.
On the first? Okay, excellent. I watched this in a deposition yesterday, but somebody else was doing it to me, so this is my first time to do this. With me being the person sharing the document. If you have any problems viewing it or it fades or whatever, let me know in the midst of questions about this, and I'll see what I can do, because I certainly don't hold myself out to be the a Zoom whiz as of yet. This is the original document that you filed in the 445th District Court of Cameron County, Texas, to start this lawsuit, is it not, sir?
Objection form.
I don't know if that is what we did to start the lawsuit, personally.
Okay. Let's let's talk about how this lawsuit came to be then for a minute. If this lawsuit was filed in November 5th, 2018, when did the events, well, strike that, did the events that the lawsuit makes actionable also occur sometime in 2018?
I don't understand your question.
Okay, let me rephrase. And that might have been awkwardly worded. I apologize. This lawsuit is about some phone calls and some communications that occurred in 2018, correct?
Objection form.
That's correct.
Okay. And in this lawsuit, you sued my clients, Blaine and Hannah Cruz. Let's skip down here. Oh, goodness. That's a restraining order. Hold on a second. In this lawsuit, you obtained a temporary restraining order against my clients, Blaine and Hannah Cruz, correct?
I believe so, yes.
Okay. Explain to me what the lawsuit was about in your own words.
Blaine Cruz had been messaging and my wife Sonia in regards to allegations of me seducing and manipulating Hannah Cruz. And he had sent a Facebook messenger to her and text her, and I believe called as well. And only her. He never called me. He never Facebooked me, he never texted me. And so after a number of times, I picked up the phone and I called him. And I asked him, and he answered the call and immediately started accusing me of seducing and manipulating Hannah Cruz, cursing, yelling, and wanted to know and wanted Sonia on the phone to hear what he had to say. So then Sonia and I were at the movies when this happened. It was just us two. Our kids were at home. When Sonia had gotten out of the movie also after me, and we proceeded, he started accusing me of these allegations. And he stated that he was a person of importance, and that this would not be the end of it until our children would be affected.
Okay. And this, did you have one call where you and Sonia were on the phone with Blaine Cruz, or was there more than one?
Just one.
Okay. Do you remember what date that occurred on?
It was in October of 2018.
Shortly before you filed the lawsuit, correct?
That's correct.
Did Mr. Cruz send you any other communications on this same subject matter?
Never.
But he did, you believe, send some messages to your wife.
Oh, he did.
After the phone call that you described just a minute ago, did you get any more did your wife get any more messages or communications from Mr. Cruz?
I don't believe so.
Okay. What did you do with respect to Mr. Cruz's actions after that phone call you just described?
We went home. I went home immediately. He threatened our kids. He said he wasn't going to stop until they were affected. And we went home to make sure our kids were okay. We called them, and they answered the phone immediately.
Do you remember exactly what you think Mr. Cruz said about your children?
What he did say is that he would not stop until they were affected, that he would not stop.
When you say the phrase "not stop," did you know at the time what he meant by that?
I believe that he was going to hurt them.
Did he say that in the phone call?
I just said that he said he would not stop until they were affected.
Did he say he was going to hurt your children?
His tone and his words were threatening, and that he would not stop until they were affected.
Did Mr. Cruz tell you on the phone call that he was going to hurt your children?
Affected means changing a state, altering a current existence. And that's what he
Objection, not
tried to do.
okay. Objection, non-responsive. I need to answer this question, Mr. Galvan. Did Mr. Cruz tell you on the phone call in 2018 that he was going to hurt your children?
No, he did not tell me, and specifically he was going to hurt my children.
Did he tell you he was going to hurt your wife?
No, he did not.
Okay. Did he tell you he was going to hurt you?
He said that if he would have known certain things at the time, that he would have put a bullet in my head. But no, he did not tell me he was going to hurt me.
Okay. And he didn't threaten with respect to you any imminent physical harm, correct?
Correct.
And he didn't threaten any imminent physical harm to your wife, correct?
Correct.
And he didn't threaten any imminent physical harm to your children, correct? Is that correct, sir?
Correct.
At some point after this phone call, I would presume that you talked to a lawyer. Is that fair?
Yes.
How long after the phone call was that?
It was pretty immediate.
The next day?
I would say the next day.
Okay. I don't want to know anything about what you said to your lawyer, if you eventually hired a lawyer, but what lawyer did you go to?
Travis Bentz.
Okay. Did you call around for any other lawyers, or did you just go to Mr. Bentz?
Objection form.
I just talked to Mr. Bentz.
Okay. And at this point, was he already your partner in 5903 Nexus through your respective LLC entities?
Yes. Do you recall how long it was after your first contact with Mr. Bentz that Mr. Bentz filed a lawsuit on your behalf that we are here on today? Within 2 weeks.
With respect, before you talked to Mr. Bentz, with respect to your actions, did you do anything else to research Blaine Cruz or Hannah Cruz in preparation for the meeting with Mr. Bentz?
Objection form.
No.
Okay. Did you review any additional communications by Mr. Cruz other than, well, let me strike that. Let me ask this first. Did you go back and look at what Mr. Cruz had sent to your wife in terms of messages, communications?
Can you repeat the question? You buffered.
Yeah, I'm sorry. You had this phone call with Mr. Cruz, and you testified that he had sent your wife some communications. Did she let you review those from her phone?
Yes.
And did y'all save those in some fashion?
No.
Okay. Were there any emails or anything other than instant messages that you looked at?
No.
Okay. Did you look at any messages or communications that Mr. Cruz had with anybody else on the subject matter of your call?
No.
Have you to this day?
Objection form.
Have I to this day looked at anything that Mr. Cruz sent to somebody?
Yeah, and let me, I'll strike that. I might have asked that in a way that it seems more broad than it is, than I was intending. Mr. Cruz made some, communications via instant message with your wife. Now, prior to filing this lawsuit, did you review any other communications made by Mr. Cruz about you and your wife?
No.
Okay. So you didn't review any communications he might have made to a church or to a school prior to you filing this lawsuit. Is that correct?
That's correct.
Okay. Now, in your testimony about this, and then certainly in your petition, you used the phrase manipulation and seduction, or seduction and manipulation. You understand that phrase that you testified about, correct? You've used it.
That is what Blaine has alleged.
Okay. Were those the words that Mr. Cruz used on your phone call?
To the best of my recollection, yes.
So Mr. Cruz said the words manipulation and seduction to you on the phone call when you and your wife were on the phone with him?
Yes.
Do you know, well, strike that. With respect to this phone call before the lawsuit, do you know, strike that again, I apologize. With respect to this phone call that occurred in October before you filed suit, did you know at the time whether or not Hannah Cruz was also on that call?
I'm sorry, can you repeat the question?
Yeah, you testified about the time that Blaine called you and your wife, and y'all were at the movies. You remember that testimony? Did you know at the time whether or not Hannah Cruz might also be on that call?
We had asked, Sonia had asked where Hannah was, and Blaine says she's right here with me.
Okay. Were y'all on a speakerphone so y'all could both hear?
That's correct.
And were you in the movies, or were you in your car, or where did you go to take this call?
We were outside the movies in the hallway.
Okay. Do you recall how long the call lasted?
No,
Is it more than half an hour?
I don't recall.
Okay, was this before you saw a movie or after you got done?
It was during.
Did you leave a movie to go take this call?
Yes.
Okay. You remember the movie? The name of the movie?
Objection form.
No.
Was the call longer than an hour?
I don't recall. It was, I don't recall. No.
Was it less than 10 minutes?
I still don't recall the exact amount of time.
Okay. Did Mr. Cruz call? Oh, let me ask this way. Who initiated this call that you had at the movies?
I called him.
You called Mr. Cruz.
That's right.
Okay. Did you call him from your phone or from your wife's phone?
My phone.
Okay. And you called him in response to messages that your wife had received on her phone, correct?
Correct.
Is that correct?
Yes, it is.
All right. Thank you. And then, like, I think you testified that the next day you were at a lawyer, you were at talking with Mr. Bentz about a potential lawsuit, correct?
No, I was talking to him about the actual phone call.
Okay. And that consultation continued, and by November 5th of 2018, actually, let me pull something else up. I had a document that I thought was inclusive of the petition. Let me correct something. I'm gonna share a different document.
And I object as to form, Mr. Chapman, on consultation.
Okay. Ms. Porter, this will be Exhibit 2. It's their original petition and application for injunctive relief. Can you see that document, Mr. Galvan?
Yes.
That's the lawsuit that was ultimately filed relating to this phone call that you had with Mr. Cruz, correct?
Yes,
And that was filed by Mr. Bentz, correct?
that's correct.
And you had retained him as your lawyer by that point, correct?
That's correct.
Did you have a written fee agreement with Mr. Bentz?
Objection form. Answer.
No,
Did you pay Mr. Bentz money before he filed this lawsuit for you?
Objection form.
no,
Can you read the title of that document for me, sir? This will be Exhibit 2.
Plaintiff's original petition and application for injunctive relief.
You reviewed this document before it was filed with the court, correct?
That's correct.
Okay, let's go forward here. All right, now I have scrolled down this document, this original petition, to a section that says facts at the top of the window. Do you see that?
Yes, I do.
Okay. And the first sentence there reads, on or about October 20th, 2018, plaintiff Sonia Galvan at 9:16 p.m. received a Facebook message from defendant Blaine Cruz. Do you see that?
Yes,
Does that refresh your recollection as to what day the messages and the call, or at least the messages to your wife Sonia occurred?
yes,
And that occurred on October 20th, 2018, correct?
that's correct.
And then you say in those messages, he sought her cell phone number and demanded to speak with both you and your wife, Sonia. Is that correct?
I'm sorry, you said that he sought her cell phone number?
Yeah, that's the next part of this. It says Blaine Cruz sought Sonia Galvan's cell phone number and demanded to speak with plaintiffs. And that, I assume that means you and your wife. Is that correct?
That's correct.
Okay. You weren't a party to these messages on October 20th, were you?
No, I was not.
Okay. Then on October 21st, in the next sentence, this petition reads, October 21st, 2018 at 6:38 p.m., defendant Blaine Cruz called Sonia Galvan's cell phone, but plaintiff did not answer. You see that?
Yes.
Is that statement true and correct?
Yes.
Okay. Immediately thereafter, in the next sentence, defendant Blaine Cruz texts Sonia Galvan and claimed that plaintiff Richard Galvan seduced and manipulated defendant Hannah Cruz in 2007. Do you see that sentence?
I do.
Is that sentence true and correct?
Yes, it is.
Did you see the text that Mr. Cruz sent to your wife, Sonia?
I did.
Did it use the word seduce and manipulated?
Yes.
Do you still have that text?
I do not.
Do you know if your wife does?
I don't know, but no, she doesn't.
So that she doesn't?
That's correct.
Then at that point, we get to the phone call we've been talking about on October 21st, 2018, 7:01 p.m. Plaintiff Richard Galvan called defendant Blaine Cruz. You see that sentence?
I do.
That's the phone call you're talking about where you left a movie and you went and sat outside the movies and you talked to Mr. Cruz, correct?
That's correct.
And that's the only phone call that you had with Mr. Cruz about this matter.
That is
correct?
correct. Yes.
Okay. And in this phone call, it's your testimony that Mr. Blaine Cruz claimed in 2007 that you, Mr. Galvan, manipulated and seduced defendant Hannah Cruz, correct?
Yes.
And he used the language manipulated and seduced per your prior testimony, correct?
That's correct.
You wouldn't do anything to change that sentence now, correct?
No.
Okay. And your testimony is that Mr. Cruz spoke in threatening tones and numerous curse words. Do you see that sentence there?
Yes.
Okay. Just briefly, what do you mean by threatening tones, sir?
When somebody, he called me curse words and elevated his voice and was yelling and if you or if I would have known, or saying those types of things.
Okay. The next sentence, the last sentence in that paragraph reads, defendant Blaine Cruz then explained he would have put a bullet in plaintiff Richard Galvan's head if defendant Blaine Cruz knew defendant Hannah Cruz in 2007. Do you see that sentence?
I do.
Is that a correct statement of what Mr. Cruz said on your phone call?
Yes, it is.
Okay. Mr. Cruz was angry in this call. Would that be your opinion?
That would be my opinion.
When you were having this call, did you understand what Mr. Cruz was angry about?
Well, he had predicated it with a text message, I believe, to my wife, so yes.
What was Mr. Cruz angry about?
that he alleging that I seduced and manipulated Hannah in 2007.
And you understood what this call was about when you took it in 2018, correct?
I called him to tell him to stop threatening my wife. That's what I did.
In 2007, you did in fact have sex with Hannah Cruz, correct?
Yes.
And you understood during this phone call that that was the subject of what Mr. Cruz was calling you about.
I understood that Mr. Cruz was very angry. He was threatening, cursed me out.
You understood at the time of this phone call that Mr. Cruz was married to Hannah Cruz, correct?
That's correct.
And Hannah Cruz, for purposes from here on out, in 2007, she's known as Hannah Lynn, correct?
That's correct.
And if I say Hannah in this deposition, you know who we're talking about, correct?
I do. Yes.
Okay. So you understood at the time of the phone call in 2018 that Mr. Cruz was mad about the fact that you had had sex with his wife. And let me preface that by saying, even though she wasn't his wife at the time and she was known as Hannah Lynn, but you understood that was the subject of the phone call.
Yes.
How old was Hannah Lynn when you had sex with her in 2017?
17.
Where did she go to church?
Northway Bible Church.
How long had you known her at that time?
I don't know exactly.
More than a month?
Yes.
More than a year?
More than a year.
Okay. Did you know her family?
Yes.
Did you know her parents?
Yes.
Who are her parents?
Richard and Starla Lynn.
Were you friends with her parents?
Yes, we were friends.
Okay. Let's get back to this petition.
Mm-hmm.
I'm going to scroll down a little bit. There is a sentence that reads, Cruz demanded that plaintiff Richard Galvan should not ever talk about anything of faith, go anywhere of faith, and will find out what defendant is going to do to him. Do you remember, with respect to that sentence, what Mr. Cruz said exactly in your phone call?
And he said exactly that.
Okay. That's as word for word as you can get it. Is that right?
To the best of my recollection.
Okay. You didn't record that phone call, did you?
No, I did not.
Okay. Did you make any notes of it right at the time that it happened? Any written notes?
No.
Okay. The next sentence reads, the following day, plaintiffs contacted plaintiff's church and advised them that the church would be receiving a similar threatening call. You see that sentence?
I do.
Is that sentence true and correct?
Yes.
Who contacted the church?
I did.
Who did you call?
I called Pastor Bill Moore.
Okay. And did you speak directly with him?
I did.
What did you say to Mr. Moore to the best of your recollection?
That we received a very disturbing call, and that in the call that our children were threatened and that those threats were not going to stop. And so I had told him that if he received or saw anything, to be on the lookout.
Did you tell him who would be calling?
Yes, I did.
Who did you identify as the person that would be calling?
Blaine Cruz.
Did you identify Hannah Cruz to Pastor Moore?
No, I did not.
Did you tell Pastor Moore, that you had had sex with Hannah Cruz when she was 17?
No, I did not.
Did you tell Pastor Moore the subject of the call that you'd had with Mr. Cruz?
No, I did not.
Did you use the words manipulation and seduction in your conversation with Pastor Moore?
No.
After you advised Pastor Moore of the threats that might be made to the church, in your opinion, what did Pastor Moore say to you?
Objection form.
Threats to my children is what it was. He told me that he would let me know if he had heard anything.
Did Pastor Moore ever contact you back and say that he had heard something?
Objection form.
What's the basis for that objection?
Hearsay.
Can you read back the question, Madam Reporter?
Did Pastor Moore ever contact you back and say that he had heard something?
You can answer the question, Mr. Galvan.
Yes, he did.
Okay. Your first call to Pastor Moore, where you advised him of what you perceived to be a threat, how long did that phone call last?
Maybe a few minutes.
And that was on October 22nd, 2018, correct?
I believe so.
Did Pastor Moore contact you back the same day?
No.
How long was it before Pastor Moore contacted you back?
A few days later.
Do you have an estimate as to what date that would have been on?
October 25th.
And the next sentence of this petition, that's Exhibit 2, reads, on October 25th, 2018 at 11:10 a.m., plaintiffs learned that defendant Blaine Cruz contacted the church the previous day and again claimed manipulation and seduction. Defendant Hannah Cruz by plaintiff Richard Galvan and plaintiff Sonia Galvan knew about it. You see that sentence?
Yes.
Does that date and time reflect a call that you received back from Pastor Moore?
What we received a I think it was a text message or a call, I forgot, from Pastor Moore saying that Blaine Cruz had called the church and had told the church alleging manipulation and seduction of Hannah. That's what we were told.
Okay. Was that told to you directly by Pastor Moore?
Objection form and a running objection to Pastor Moore's statements.
Yes.
And was it told to you via text or via a phone call?
I don't recall.
Do you have any text from that time period from Pastor Moore that you have saved?
No.
Did anybody else from the church contact you on this subject?
No.
Do you know if Mr. Cruz made any additional contacts with the church?
I believe so.
Do you know when those were made?
I do. I'm not exactly sure.
You kept any records that would reflect when those additional contacts with the church were made by Mr. Cruz to your information and belief?
No.
Did your wife, Mr. Galvan, did your wife Sonia have any of these contacts with the church as well as yourself, or was it just you?
It was just me.
Was anybody else, to your knowledge, strike that, to your knowledge, was anybody else from the church on the phone call that you had with Pastor Moore?
No.
All right, I want to go down a sentence here. Because of the threats made in October 26, 2018, plaintiffs contacted Children's School and warned them of the likely campaign of defaming communications coming from defendant Blaine Cruz. Do you see that sentence?
I do.
And your opinion as we sit here today, is that sentence true and correct?
Yes.
Use of,
Yeah.
is that a yes, sir?
Yes.
There is a phrase in there, 2 words, defaming communications. Do you see that?
I do.
The time that this petition was filed, what was your understanding of that phrase in your own words?
Seduction and manipulation.
Okay. Your testimony is that the words seduction and manipulation were defaming communications. Is that correct?
Yes.
What does the phrase defaming communications mean?
In what aspect? I'm not
What
sure.
does it mean? What does it mean to you?
Okay. You kind of asked the question, so if you would give me a little bit clearer.
Sure. Let's start with the first word, defaming. What does that mean to you?
It means like bad stuff, things that are untrue.
And you understood that to have the same meaning at the time that you filed this petition in 2018?
That's correct.
What was untrue about the communications from defendant Blaine Cruz?
That I seduced Hannah and manipulated her.
So when you filed this petition in 2018, you're stating that the defaming communications were A, that you seduced Hannah, correct?
Correct.
And your position was at the time that you did not seduce Hannah, correct?
Correct.
Is that still your position today?
Yes.
What does seduce mean to you?
It means to seduce. It means that you would, or somebody would, try to entice somebody to do something that would be incorrect, or over another better judgment.
When you say incorrect in this context, you're referring about something romantic or sexual, correct?
That's correct.
So you have defined seduce as doing something to entice the person into something romantic or sexual, correct?
Yes, that's correct.
At this time in 2018, when you're having these conversations and then filing this lawsuit, you hadn't forgotten that you had sex with Hannah Cruz in 2007, had you?
No.
So your claim with regards to the defamation or defaming communications in this sentence is that you had sex with her, but you didn't seduce her. Is that correct?
Objection form.
The claim is that is the allegations of seduction and manipulation.
Okay. Right now, we're just talking about seduction. We'll handle manipulation in a minute. So to be clear, with respect to seduction, you said a minute ago in your testimony that that was false. Do you remember that testimony?
That's correct.
And then you defined seduction as enticing someone into something romantic or sexual. Do you remember that testimony?
I do.
And in 2007, you did in fact have sexual intercourse with Hannah Cruz. Is that correct?
That's correct.
Is it your position in this lawsuit, when you filed it, that you had had sex with Hannah Cruz in 2007, but that act did not rise to the level of seduction?
That's correct. I did not seduce.
So you weren't denying when you said seduction was false, you're not denying romantic or sexual. You're simply saying that you didn't entice her into that.
That's correct.
Okay. Where did your sexual encounter with Hannah Cruz occur in 2007?
At the La Quinta Hotel in Mercedes, Texas.
So was it in a hotel room?
That's correct.
Had that hotel room been rented for one day?
That's correct.
Who rented that hotel room?
I did.
Did you rent that hotel room specifically to have sex with Hannah Cruz, Hannah Lynn at that time?
Yes.
How long were you in that hotel room?
I don't recall exactly, but it probably maybe 20 minutes or less. I don't know.
You didn't spend the night there?
No.
Did you go to the hotel by yourself?
I did, yes.
Did you then invite Hannah Cruz to meet you at the hotel room?
No, not then.
Had you previously invited Hannah Cruz to meet you at the hotel room?
That's where we agreed to meet.
Did you contact her once you obtained the room?
She showed up.
Did you invite her? Did you contact her once she obtained the room?
She showed up to the room.
The objection non-responsive. My question, Mr. Galvan, is did you contact Hannah Cruz once you obtained the room at the La Quinta?
No.
If you did not contact Hannah Cruz once you obtained the room, how did Miss Cruz know what room to go to?
She showed up and was inside. Yeah, she showed up to the hotel room and was inside the hotel, and then we went to the room.
Okay, so you met her downstairs in the room,
That's correct. In the hotel.
in the common area of the hotel.
That's correct.
You then invited her to the room that you had rented, correct?
We went to the room together.
Did she go to that room without your permission?
I didn't ask her.
Mr. Galvan, did Hannah Cruz go to your hotel room at the La Quinta without your permission?
I don't understand the question. We both went to the hotel room.
And that's because you'd invited her to go up to your room, correct?
We had agreed to meet there and go to the room.
Whose idea was that?
It was both of ours.
All right, let's go back to this word defaming that you used in your original petition. Talked about two words as defaming, meaning false communications. One was seduction. The other word is manipulation. Do you remember that testimony?
Yes.
Is it your contention in this lawsuit that communications stating that you had manipulated Hannah Cruz were false?
Yes.
Did you see any communications with any party, not you or your wife, any third party, where Blaine Cruz uses the word manipulation prior to filing this lawsuit?
No.
You don't know if he used the word manipulation, do you?
I don't know if he used the word manipulation. He used it with me and my wife.
Objection to the non-responsive portion. You don't know if Mr. Cruz communicated to any third party using the word manipulation, do you?
No.
And you didn't at the time that you filed this lawsuit, did you?
No, I did not.
And if Mr. Cruz had called some third party and said, Mr. Richard Galvan had sex with my wife, Hannah Cruz, when she was 17, and her parents were family friends of his, would there be anything untrue about that statement?
Can you repeat that again?
Sure. If Mr. Cruz had called a third party in 2018 and said, Mr. Galvan had sex with Hannah Lynn in 2007, would there be anything untrue about that statement?
No.
If Mr. Cruz had said, at that time, Hannah Lynn was 17 years old, would there be anything untrue about that statement?
No.
If he said at the time, Hannah Lynn was between her junior and senior year of high school, would there be anything untrue about that statement?
No.
If he said at that time, Hannah Lynn went to Northway Bible Church, would there be anything untrue about that statement?
No.
If he said at the time, Mr. Galvan participated in mission, raising money and helping with mission trips for the youth of Northway Bible Church, would there be anything untrue about that statement?
Yes.
What is untrue about that statement?
It was for the whole church.
Okay, thank you for the clarification. The next sentence of this petition reads, on October 29th, 2018, at 5:33 p.m., plaintiffs received confirmation that defendant Cruz attempted to contact a school administrator of plaintiff's children's school. Do you see that sentence?
Yes.
Okay. On October 29th, how did you receive confirmation as described in that sentence?
I received a call from Mrs. Tammy Johnson, a cell phone, and the actual person on the phone was Mrs. Karen Zeisel. And Mrs. Karen Zeisel stated that Blaine Cruz had contacted Tammy Johnson and had sent her similar information that he had discussed, from what my understanding is, with the church. And
did you see or review any of the actual communications Mr. Cruz made to the school?
no,
Did your wife have any involvement in communicating with the school?
no,
Were those calls or that communication with the school was via telephone call or was it via text message?
I believe that he tried contacting her many times on various venues of communication.
Let me clarify. Your communication with the school, was that on a phone call or was it via text message or email?
It was a phone call.
Just one call?
Yes.
Did you have any subsequent calls with the school about Mr. Cruz?
No.
Did your wife?
No.
Through all these communications that we have covered thus far in this petition, and all the conversations that you've discussed thus far in your deposition on the subject of Blaine Cruz and Hannah Cruz, were there any statements to your knowledge ever made by Hannah Cruz?
When I had called Blaine and he acknowledged that Hannah was there in the room with him, and he went on to threaten us and our children, it was our understanding that she was there with him on the phone.
Okay.
In the room.
Did she say anything to you?
She never said anything.
Did she say anything to your wife?
No.
At the time you filed this lawsuit, did you have any knowledge that Hannah Cruz had communicated with the church?
No.
Did you have any knowledge that Hannah Cruz had communicated with the school?
No.
Had Hannah Cruz made any communications with your wife?
No.
Had she made any communications with you?
No.
The last sentence of this fact section reads, defendant Blaine Cruz's actions have caused plaintiffs to experience feelings of great fear, intimidation, and mortification. Do you see that sentence?
Yes.
What did you fear that you're referring to in that sentence?
That he would not stop until our children lives daily lives and would be affected, that he would not stop until they were harmed in some way. That if I ever did anything with a church, that he would ensure that I would be harmed as well. That after he called the church and the school, we were mortified that we wouldn't know what he would do. He could show up to the school. He could show up to our church services. He could show up to our house. And he just would, so we lived in fear.
Okay.
Lived in fear that he would shoot me, put a bullet in my head, just constant fear of doing something to the kids, all right?
No.
If he's calling the church into school, then we're feared that he would show up to the school, that he would try to do something to them, that he would try to hit them, he would try to hurt them, because he said he wouldn't stop until he made sure that they were affected, that he made sure that they were affected.
I'm going to go back up. I'm scroll back up to page 2 of your petition. Last sentence of the paragraph before the end of the page. Defendant Blaine Cruz claimed this phone call would not be the end and plaintiff's children would learn as well. Do you see that sentence?
Yes.
Is that true and correct?
Yes.
Is that a threat to your children the way that sentence reads?
Absolutely.
Is the threat to your children the fact that they might find out that their father had sex with a 17-year-old high school student, not his wife?
No, the threat to our children is that they would learn to live in fear and intimidation and mortification, that they would be threatened and that they would learn what that felt like.
Now, you've testified earlier that Mr. Cruz never made any threat of any imminent harm to either you, your wife, or your children. That was your testimony just a few minutes ago in this deposition. You remember that?
Objection form.
No,
You don't remember that testimony?
I remember you asking me if he threatened me. I don't
Objection
remember.
form. I believe the words were imminent physical harm.
Any imminent physical harm. Do you understand the clarification now? Do you remember that testimony?
Yes.
Okay. Mr. Galvan, you were fearful that Mr. Cruz would out you as somebody that had sex with a high school student when you were 38 and she was 17. Isn't that right?
No.
You didn't care about that at all?
No, I care about my kids. I care about my wife. I cared about what he was going to do to them.
You didn't care about the people at the church finding out about that situation?
No.
You didn't care about the people at the school finding out about that situation?
Of course I care. Of course I do.
Did you fear that they would?
Did I fear that they would? No,
Yes.
I didn't fear if they would or if they would not. Of course I would care.
Would it be fair to describe if the church, people at the church had found out that you had sex with a 17-year-old high school student while you were a 38-year-old married man, would it be fair to say that you would be mortified by that knowledge that is spreading through your church?
I don't know.
Okay. We've been going about another hour and 15 minutes. I'm going to take a short break. Let's all stretch our legs and get a drink or whatever we need to do, go to the bathroom, and we'll come back in about 5 minutes. Is that all right with you, Mr. Galvan?
That's fine.
Thank you.
We're off the record.
All right, let's get back on the record then. We come through the fact parts of your original petition, Mr. Galvan, and we've been reading from that, correct?
That's correct.
Going up on the exhibit 2 that we've been using, the facts start on page 2 and go through the bottom of page, almost to the bottom of page 3, correct?
Yes.
I'm sorry, I didn't mean to confuse you by scrolling.
Yeah.
With respect to that fact section, as pled in 2018, are there any factual statements contained in that section as we sit here today that you would say are not true and correct?
No.
Let's move on along then to the next section at the bottom of page 3. There's a heading called causes of action. Do you see that?
I do.
Okay, and you understand that these are the legal causes of action that you brought against my clients, Blaine and Hannah Cruz, back in November 2018, do you not?
Yes.
Okay. First subheading there sees request for permanent injunction against defendants. Do you see that?
Yes.
At the time that you filed this case, what was your understanding of a permanent injunction?
I believe that it was that there would be no communication. They would be prohibited from contacting and communicating with in regards to allegations of manipulation and seduction with our family members, immediate family, friends, place of worship, of attendance, schools of attendance, anywhere our kids would be associated, or clients and potential clients, and the such.
Okay. You understood the word injunction, or to enjoin me, and you were seeking a court order to stop them from making communications, correct?
I was seeking, yes, that's correct.
And you wanted the district court in Cameron County, Texas, to order that both Blaine and Hannah Cruz could not make any communications on this subject, correct?
That's correct.
Okay, let's look at this first sentence. The plaintiff's requested injunctive relief includes the court enjoined defendants from communicating, regardless of any form or fashion, in any way, let's communicate in any way, and then back on the petition, regarding any actions or occurrences alleged or otherwise between plaintiffs and defendants, particularly associated with allegations of manipulation, seduction, or otherwise. You see that sentence?
Yes.
And that accurately frames your request to this court as of November 2018, correct?
That's correct.
And then that sentence goes on to anyone. Do you see that? Top of page 4. Let me scroll up. It's right. I don't know if you can see my mouse or whatever.
Right.
Okay. So you wanted Mr. Blaine Cruz, my client, and Mr. Hannah Cruz, my client, to be court ordered not to communicate about the subject matter of things between you and them, correct?
Objection form.
It's with the allegations of manipulation and seduction.
Okay. And anything associated with the allegations of manipulation and seduction, correct?
It's in particularly associated.
Okay. Particularly associated with those allegations, correct?
That's correct.
And you would certainly agree with me that a sexual encounter would be associated with those allegations, correct?
No.
Why not?
Because there's because of the manipulation and seduction aspect.
What's the word after seduction on the top line of page 4?
Or otherwise?
There you go. So particularly associated with allegations of manipulation, seduction, or otherwise. You see, that was your phrase that you asked your lawyers to prepare and ask this court for relief on, correct?
Objection form.
Is that correct?
That is conversation between my attorney and I, correct?
I'm just talking about the pleading here, sir. Again, I don't want anything.
Well, it does say otherwise.
Yeah. You're not telling this court and this judge and jury in this case, as we sit here today, that you aren't trying to stop Blaine and Hannah Cruz from talking about your sexual encounter, are you?
Objection form.
No, I wasn't trying to stop them from talking about our sexual encounter. I didn't want him at our schools. I didn't want him or at our church or our place of residence. I didn't want him to, with allegations of manipulation and seduction.
You didn't want him to talk about your sexual encounter at those places as well, correct?
Objection form.
The allegations of manipulation and seduction.
Objection non-responsive. Were you also seeking that Mr. Cruz and Mrs. Cruz not be able to talk about the sexual encounter to the church and the school?
No,
That wasn't a part of this lawsuit.
no.
And you wanted Mr. and Mrs. Cruz to be permanently enjoined from coming within 1,000 feet of you and your family members, correct?
Yes,
And you were seeking to enjoin both their freedom to speak, correct?
no,
You weren't trying to enjoin their freedom to speak?
no, I was not. To lie, yes, but not freedom to speak.
You were trying to enjoin them from making communications, correct?
To lie? Is that, if that's communications, then yes.
Okay. Objection non-responsive. You are trying to enjoin them from making certain communications, correct?
There are allegations about manipulation, seduction in regards to that communication. That is correct. I don't want him 1,000 feet from our kids because he had already threatened to put a bullet in my head. They could get shot. I didn't want him to continue to seek out having our kids learn what it was going to be like to live in fear and live in mortification. That's what I didn't want. I didn't want him to stop harassing my wife.
And you were trying, objection to the non-responsive portion, you were also trying to enjoin their physical freedom, correct?
No,
You weren't trying to keep them 1,000 feet away from you and any family member? You were, weren't you?
yes,
So you were trying to enjoin their physical freedom to go where they wanted to go, correct?
we sought this so that they wouldn't come around our kids, where our family was, our family, the churches that we went to. That's what we did.
Correct. So places like a church that they would otherwise be free to go to, you were trying to enjoin their physical freedom to go there, correct?
No.
Is that correct, sir?
No.
Well, if they couldn't come within 1,000 feet of your family members, your home, your business, attended churches and schools, you would agree that certainly with respect to the church, they would otherwise have all the rights in the world to go there. It's a public place, correct?
They had no legitimate reason to be there.
Is that an opinion or a fact, sir?
Oh, that's what I'm saying. They didn't have a legitimate reason to be around there, then no, they didn't need to be around my kids.
You didn't want them to go to your church, and you tried to enjoin them from staying 1,000 feet away from the church, correct?
I didn't want them to go to where my children were at.
Objection non-responsive. Sir,
My children attended church, and that's what I didn't want him to be at, where my children were attending. That's what it says. Schools
you
of
would,
attendance.
you would agree with, I'm sorry, go ahead, sir.
It says places of worship of attendance, schools of attendance.
Attended churches, do you see that phrase?
I see places of worship of attendance.
Okay. Court enjoined plaintiffs from coming in within 1,000 feet of plaintiffs or plaintiffs' family members and plaintiff's home. You didn't want them to come within 1,000 feet of your home, correct?
Yes,
You didn't want them to come within 1,000 feet of your business, correct?
yes,
You didn't want them to come within 1,000 feet of any church you attended, correct?
yes,
And you didn't want them to come within 1,000 feet of the schools where your children went, correct?
that's correct.
And to the extent that they would otherwise be free to do those things, you were asking for an injunction to prevent them from doing that, correct?
Yes,
I'm going to scroll up a little bit. The cause of action we're now on page 4 of Exhibit 2. There's a subheading for assault. Do you see that as subheading?
I do.
Okay. It says, in addition and or in the alternative to all other claims, plaintiffs seek recovery under a theory of assault. Specifically, defendant Blaine Cruz intentionally or knowingly threatened plaintiff Richard Galvan with imminent bodily injury. Do you see that phrase?
Yes.
That never happened, did it?
He stated that in 2007, if he would have known, actually, I'd take that back. If he would have known when he met me what he believed allegedly happened, he would have.
Mr. Cruz never threatened you with imminent bodily
bullet
injury.
in
did
my
he?
head.
No, sorry. I apologize. I thought you were done, sir. Mr. Cruz never threatened you with imminent bodily injury, did he?
No.
But you allege that he did in this petition filed in November 2018, didn't you?
Yes.
And on May 13th, 2020, which is yesterday, you filed a discovery response stating you were no longer making that contention, correct?
Yes.
The next heading is intentional infliction of emotional distress. Do you see that heading?
Yes.
With respect to the assault claim, you understood in this petition that you were seeking monetary damages relating to that, correct?
I don't see it there.
No. Did you understand that you were asking for money from the Cruzes in this lawsuit?
Objection form.
What's the basis?
Legal opinion. And you haven't
I asked
pointed
for his, I'm sorry, go ahead.
and you haven't pointed it out in the petition in a damages paragraph. So
No, we're not there. Was it your understanding when you filed this lawsuit in November 2018 that you were seeking significant monetary damages from the Cruzes?
No.
You didn't know that you were doing that in this petition?
You have to refresh my memory if you don't mind. And all I see is this here. So, and this doesn't show me anything. Would you, is there?
We'll get there. We're going to scroll through. But as we sit here today, you're telling me that you don't remember whether you were seeking money from the Cruzes in 2018.
If it's in here in the petition, then yes. But can you scroll up? Is it in there?
We're going to do question and answer format, Mr. Galvan. I'm asking about your knowledge right now. With respect to your knowledge right now, you don't remember in 2018 whether or not you asked for damages against Mr. and Mrs. Cruz in terms of money?
No.
Okay. And your testimony is we'll need to refresh your recollection with that in this petition, correct?
That's correct.
Let me ask you this question. Was the main part of this lawsuit, was the main point of this lawsuit for you when you filed it in 2018 to keep the Cruzes from coming around?
Coming around where?
You, your family, your churches, your schools. Was that the main point of the lawsuit in your mind?
No.
What was the main point of the lawsuit?
That they had intentionally inflicted emotional distress upon me and my family, upon my wife, that he was going to continuously make my children and my wife's lives threatened, to stop untruths, and to protect to protect the well-being of my kids and my wife.
All right. On the intentional infliction of emotional distress paragraph that's visible on our window right now in Exhibit 2, it says, in addition and an alternative of all other claims, plaintiffs seek recovery under a theory of intentional infliction of emotional distress. You see that?
I do.
Did you have, at the time that you filed this petition in 2018, any understanding yourself of the elements necessary to recover under a theory of intentional infliction of emotional distress?
No.
All right, the next sentence reads, defendant Blaine Cruz acted recklessly when he communicated such allegations of manipulation and seduction without any merit or physical proof. You see that sentence?
Yes.
If something is true, why does somebody have to have physical proof about it before they communicate it?
Objection form.
I don't understand that question at all.
You're saying in this petition, in that sentence, that Mr. Cruz acted recklessly because he communicated allegations without any, number one, merit, or number two, physical proof. Do you see that sentence where it says physical proof?
I see allegations of manipulation, yes, without any merit or physical proof.
Okay, we're going to set merit aside for now. We're going to talk about the physical proof. Is it your position that Mr. Cruz would have to have physical proof in order to communicate something that was true?
Objection form.
Still don't understand the question.
I'm asking you why the word physical proof is in this paragraph. Bottom line, do you know?
So that there's proof,
Why physical proof?
because it brings speculation. If
Something was true with respect to the allegations in this petition, but the person communicated it didn't have physical proof, in your opinion, would that be reckless?
No,
Objection form.
I still don't understand it. You're saying if, and so if is if. That's what I kind of get from your question.
I'm asking you, Mr. Galvan, if you believe it would be reckless just because somebody communicated something without physical proof.
Without merit or physical proof, yes.
No, I didn't. The objection not responsive. I skipped merit.
Yes. Answer the question is yes, yes, without physical proof.
Okay. Would the same be with respect to merit?
Objection form.
Yeah. Yes.
Okay. Plaintiff suffered emotional distress when defendant Blaine Cruz communicated allegations to the plaintiffs. You see that sentence?
Yes.
And it's comma, and then it carries, same sentence carries on, plaintiff's place of worship and the children's school. You see that full sentence, correct?
Yes.
What emotional distress did you suffer regarding the allegations contained in that sentence?
Objection form.
Well, he communicated to areas and called them where our children attend.
Next sentence reads, defendant Cruz's conduct was extreme and outrageous because of the nature and content of the statements and the pure lack of physical proof. You see that sentence?
I do.
Okay. You were saying in this petition that Mr. Cruz's conduct was outrageous and extreme because of the content of the statements and the lack of physical proof, correct?
Objection form.
Yeah, his conduct absolutely was extreme and outrageous. I agree with that.
And those two phrases, content of statements and pure lack of physical proof, are joined in that sentence by the word and, correct?
That is how it is written.
Yeah. Meaning that if physical proof, if there was physical proof, then you don't think his statements would be outrageous.
I think his conduct and whether it's his statements, his conduct, and calling my kids' schools and calling my kids' churches, place of worship, where they were spending most of their time through the work during the week, and us on the weekend is extremely outrageous of his conduct.
Let me ask you this question, Mr. Galvan. Let me back up from trying to talk about words in a sentence with you. Is there some reason when you filed this petition in 2018 that you thought it had to be important that Mr. Cruz had physical proof of something?
Well, he's alleging manipulation and seduction, and so that is exactly what we filed.
Okay.
Emotional distress. I still don't understand the entirety of the association with physical proof, but that's the best I could actually answer.
I understand.
Still don't know.
Let me ask you this question. In your opinion, what could be physical proof of manipulation and seduction?
My opinion. Could be I don't know, pictures, maybe some communication, verification, those things.
I'm going to move along to the top of page 5 of this petition. It says further, on the bottom of page 4, it says further for argument purposes only, comma, if the alleged actions that occurred 12 years ago were determined to be true, determined as true, such allegations are not actionable. When you filed this, you see that part of it right there?
Uh-huh. Yes.
Okay. And it goes on to say, is they are well beyond the statute of limitations and age of consent.
Yes.
What statute of limitations are you talking about there in that petition?
I don't know.
What age of consent are you talking about there in that petition?
I don't know.
You don't know what that sentence means, really, do you?
Not in its entirety.
The next cause of action under a heading on page 5 of Exhibit 2 is labeled defamation per se. Do you see that?
I do.
Okay. It says, in addition to an alternative to all other claims, plaintiffs seek recovery under a theory of defamation per se. Do you see that?
I do.
When you filed this petition, what did you understand defamation per se to mean?
Accusations and allegations of turpitude, moral turpitude, criminality, involving loathsome disease. It's
Okay. And that's found at the bottom of that paragraph, correct, in your petition?
That's correct.
Okay. In 2018, why did you believe Mr. Cruz's statements to third parties are so likely to injure the person's, your reputation, that they should be considered defamation per se?
Can you repeat the question, please?
Sure. In 2018, when this pleading was filed, why did you believe Mr. Cruz's statements are so likely to injure your reputation that they should be defamation per se? Do you have an understanding as to why you believe that what he said was defamation per se?
Saying that I, as a youth pastor, seduce Hannah, a young woman.
Yeah. Your testimony is here today that you weren't a youth pastor. That's correct, right?
That's correct.
Okay. And your testimony today has been that you had sex with Hannah, but you did not seduce her, correct?
That's correct.
And your testimony has been that you did not manipulate her.
That's correct.
But yet you claimed in your petition that, well, strike that. Is there anything that you recall in the factual statements in your petition where you say Mr. Cruz said that you were a youth pastor?
No.
Your next claim is under the heading Public Disclosure of Private Facts. Do you see that heading?
Yes.
It says in the alternative to the other counts, assuming for argument's sake, defendant Blaine Cruz's allegations are true. Plaintiffs plead recovery under public disclosure of private facts. What was your understanding of that claim at the time this petition was filed?
Objection form.
I don't know.
Okay. Did you know that you were claiming that you should be entitled to money even if what Blaine was saying was true?
Objection form.
I don't.
You didn't know that at the time?
No.
The next heading here is entitled Gag Order at the bottom of page 5. You see that?
Yes.
Okay. So the court may issue a gag order if, after a hearing, it finds there's a danger of an imminent and irreparable harm to the judicial process, which would deprive litigants of a just resolution to their dispute, and 2, the action represents the least restrictive means to prevent the harm. You see that?
Yes.
And then it goes on to say, when a court issues a gag order, it must identify the person to be restrained and identify the limits of the restraint. Do you see that?
Yes.
And then from the last word on page 5, the gag order requested in this motion asks the court to restrain defendants from making any reference, intentionally, willfully, or negligently, of any kind related to any pending litigation between the plaintiffs and defendants and the associated allegations within the litigation. Do you see that?
Yes.
So what you were wanting to do in this was stop the Cruzes from communicating anything while this case was going on, correct?
Yes.
Was that the main point of your lawsuit against the Cruzes in your mind when you filed this in 2018?
No.
Okay. All right. This should answer some questions that we had before about what you were seeking. There's a paragraph, the next heading is titled Exemplary Damages. Do you see that?
Yes.
Based on the intentional torts and gross negligence committed by the defendants alleged here and above, plaintiffs seek an award of exemplary damages of and from the defendants in amount within the jurisdictional limits of this court. Do you see that?
Yes.
That's an asking for an award of money to punish Blaine and Hannah Cruz, correct?
Objection form.
I don't know.
Is it seeking an award of money?
I don't know.
Did you know at the time that you were seeking money from Blaine and Hannah Cruz based on this paragraph?
No.
Did you read this paragraph before you verified the petition?
Yes.
And you didn't read that to understand that you were seeking an award of exemplary damages, meaning money from the defendants?
Yes.
You knew that, right?
I'm sorry, can you repeat the question?
You knew you were seeking money from the defendants when you filed this lawsuit.
Yes.
Okay. And then at the bottom of page 6, there's a heading entitled Application for Temporary Restraining Order, correct?
Yes,
And that goes on for a bit with some citations. As somebody that's not a lawyer, you weren't familiar, I take it, with the particular legal requirements of obtaining a temporary restraining order from a court when you filed this, correct?
correct.
And that's something you left up to your attorney.
That's correct.
As an aside, at the time that this petition was filed on November 5th, 2018, had Mr. Jim Young started to work for you as well?
I don't believe so.
And then there's another section on temporary injunction on page 8. At the bottom of page 8, you see that? I'm about to scroll up to the next page. You see that heading?
Yes, I do.
And as somebody that's not a lawyer, you wouldn't be in a position as we sit here today to offer any commentary about whether the merits of a temporary injunction, correct?
Correct.
You were seeking your attorney's fees to be paid by Blaine and Hannah Cruz, correct?
Correct.
And that's found on page 9 of this petition, a heading called attorney's fees, correct?
Yes.
Okay. And then there's a heading titled conditions precedent. All conditions precedent to the plaintiff's claims have been performed or have occurred. As a lay person, do you have any understanding what that meant in your petition at the time you filed it?
No.
You see a section after that entitled prayer.
Yes.
Okay. It starts out, wherefore premises considered, plaintiffs pray that defendants be cited and appear and answer herein, and after final trial hereof, that the plaintiffs, it says shave judgment. I'm going to submit to you that's most likely a typo and ask you to understand that to mean have judgment against defendants as follows. You understand this is your request for a judgment in this lawsuit that you filed, correct?
Yes.
And the A is actual and special damages from defendants in an amount no less than $335,000 associated with plaintiff's claim of defamation, plus $500,000 associated with pain and suffering as requested herein above. Do you see that sentence?
Yes.
Would you agree with me that you filed a petition against Blaine and Cruz asking for at least $835,000 on November 5th, 2018?
Yes.
With respect to the claim for defamation and the $335,000 you requested, did you make any calculation to get to that number before you filed this pleading?
I don't know.
Do you know where that number came from?
No.
Okay, with respect to the $500,000 number that comes right after that, you see that?
Yes.
If I say $500,000, it's the same thing, right?
Correct.
You're asking for $500,000 associated with damages associated with pain and suffering. You see that?
Yes.
What pain and suffering were you asking $500,000 to be compensated $500,000 in relation to?
Blaine's continued action to ensure that my children's lives would be threatened, that they would live in fear, mortification, that he would not stop. We lost sleep, headaches, emotional pain, and still living in fear.
All right, going back up a minute to recount the causes of action you pled in this lawsuit when you first filed it. You asked for causes of action. You asked for injunction. You see that where I'm pointing to on the exhibit?
Yes.
You made a claim of assault, correct?
Correct.
Associated with a threat of imminent bodily injury according to your pleading at the time, correct?
Yes.
You made a claim for an intentional infliction of emotional distress. You see that?
Yes.
Defamation per se. Do you see that?
Yes.
Public disclosure of private facts. You see that?
Yes.
Gag order. You see that?
Yes.
And exemplary damages. You see that?
Yes.
Temporary restraining order. You see that?
Application, yes.
And there's an attorney's fees and a damages section down here, and we went over those, correct?
Correct.
With respect, let me go back up here to your claim for assault. You voluntarily non-suited that with prejudice this year in 2020, did you not?
Yes.
Do you believe, as we sit here today, that Mr. Cruz committed an assault against you and your wife?
No.
What has changed from 2018 to 2020 to make you change your mind?
I have. And my attorney. Mrs. Nix.
That's based on consultation with Mrs. Nix.
Yes.
With respect to intentional deflection of emotional distress, do you believe, as we sit here in 2020, that you have a claim against Blaine Cruz and Hannah Cruz for intentional infliction of emotional distress?
Objection form.
I don't know how to answer that.
Okay, let me ask it this way. We'll do it the same way we did the other. You voluntarily non-suited with prejudice your claims of intentional infliction of emotional distress for both you and your wife, correct?
Yes.
As we sit here in 2020, do you believe that you had claims for intentional infliction of emotional distress against the Cruzes?
Yes.
Why did you non-suit them?
Consultation with my attorney, Mrs. Nix.
There's a claim for public disclosure of private facts. You voluntarily non-suited that claim with prejudice, correct, sir?
That's correct.
As we sit here today in 2020, do you believe that you had a cause of action for public disclosure of private facts back in 2018?
No.
What has made you change your mind from 2018 to 2020 about whether or not you had this claim for public disclosure of private facts?
Consultation with our attorney.
I don't know anything that you said about, about this lawsuit. I don't know anything you said with Ms. Nix or she said to you, but I do want to know when you first consulted with Ms. Nix.
Objection form.
You can answer.
That would be something that that I would have discussed with Ms. Nix. And you said you didn't want to know anything I discussed with Ms. Nix.
No, but with regard to the date.
Oh, the
I just
date?
want to know when did you first contact Ms. Nix in relation to this case? What day?
I don't recall.
Okay. You agree with me that you acted as pro se counsel, pro se, meaning you represented yourself in this period of time, for a small period of time in this case, correct?
That's correct.
And you filed non-suits in this case of your causes of action before Ms. Nix was involved, correct?
That's correct.
Okay. When you filed your non-suits as pro se, you filed a non-suit of your public disclosure of private facts claim by yourself without a lawyer, correct?
That's correct.
What changed between 2018 and 2020 to make you dismiss your non-suit, your public disclosure of private facts claim?
I don't understand your question. I'm sorry.
You filed a non-suit of your public disclosure of private facts claim representing yourself. And I asked, and my question is, what changed between 2018 and 2020 when you filed that representing yourself to make you non-suit that claim?
Just consultation with Travis and Jim for withdrawal.
Consultation with your prior attorneys?
That's correct, before they withdrew.
Would the same be true of all your non-suits that you filed as a pro se?
Yes.
Okay. Were those actually filed from Jim Young's e-filing account?
Excuse me?
Were those non-suits filed from Jim Young's e-file account?
I don't know. I don't know.
Yeah, you didn't file them yourself electronically, correct?
Myself?
Yes.
I'm sorry, I'm a little confused. You asked
Yeah,
me.
just to be clear here, Mr. Galvan, you're acting as your own counsel for a period of time, but when you filed some of the things that you file as pro se, meaning acting as your own counsel, you didn't log in and register an account with the Texas e-filing system and file those under an account that you made up to do that. You used Jim Young's electronic filing account, correct?
No, I did my own. I have an account with e-file.
Okay, thank you. All right. All right, I'm gonna go. There's an affidavit verification from Sonia, but let's go to yours. You understood at the time that you filed this lawsuit, November 2018, that your petition needed to be verified by some sworn statements, correct?
Yeah, I'm sorry, say that again.
Your petition filed in November 5th of 2018 needed to be supported by some sworn statements that were notarized, correct?
I don't know.
Well, you provided a sworn statement, correct, in conjunction with the petition?
That's correct.
And you don't know why you needed to do that?
No.
Okay. All right. The first paragraph of this that I have up now, and it's page, can't tell what page this is. Is it numbered? I don't think it's numbered. You recognize this verification that you filed, correct? It's attached to the back of Exhibit 2.
Yes.
Okay. It says the first quoted paragraph for you says it says you were administered oath, and then you said the following: my name is Richard Galvan. I read the plaintiff's original petition and application for temporary restraining order, and the facts stated therein are within my personal knowledge and are true and correct.
Mr. Chapman, not to cut you off, but Sonia just returned with lunch. If it would be.
Okay, that's perfect. Before we get into this, let's take a short break. Whatever you want, 30 minutes?
Yes, please.
Okay, thank you.
Yes, thank you. 30 minutes, you got a time on that?
Yeah, I got 129, 130.
Yeah, it'll be 2 o'clock.
Thank you.
Thank you, sir.